Thanks for attending. My name is John Benford, and I apparently in our absence, introductions have already been made, so I won't go through and introduce everybody. But
I didn't introduce each one individually, so.
Okay, so we can do that.
I just did an overview. So.
Oh, just
yeah.
Okay,
so if you guys can introduce yourselves like one at a time, that'd be great.
All right. Well, my name is John Benford, and I'm Vice Chair of the Orange County Bar Association Professionalism Committee. I've been practicing. I'm an attorney in Orlando. I'm with the Orlando office of Wilson Elser. I've been practicing now for roughly 24 years. I practice in the area of commercial litigation, and what did you whisper?
Chair.
Oh, chair. I think my colleague Robert Moore wants me to sit down and stop screaming. And then we'll go around and just everybody introduce themselves real briefly.
Okay, sure. My name is Kishara Cowens. I am bar counsel with the Orlando branch of the Florida Bar. I work in the area of lawyer regulation, and so essentially my job function is I investigate the bar complaints that are filed against attorneys, and I prosecute the attorneys that we believe have violated the rules regulating the Florida bar. I've been with the bar for 8 years. Last month, well, not last month, we're in November now, September made 8 years that I've been with the bar. I've been an attorney actually for 9 years. I started off at the public defender's office here in Orlando before I transitioned over to the Florida bar.
I'm Robert Moore. I've been an attorney for about 3 years. I graduated from FAMU, so I'm pretty, can still remember the pains of the bar exam and, wake up in the middle of the night and go, oh God, what day is it? Driving through Tampa is still a bad thing. So I practice in real estate law. I've been in Orlando, got involved in the OCBA, which I would suggest all you guys do as law students if you have the opportunity and the time, which is kind of a joke. But my advice would be to just get involved, try to go to court, try to learn a little bit about what's on the outside.
Good afternoon. My name is Eric Bowman. I'm an attorney and practice primarily in litigation, business litigation, and do some work related to technology, software, some of the issues that we're going to talk about today. I've been in Orlando for a little over 10 years. Started practicing out west. Been out here since 2005. I have a firm with a total of 12 attorneys split up between transactional and litigation. And so not only am I responsible for myself, but people look to me in the firm oftentimes for policy decisions with respect to our use of technology.
Let me just say a few words before I pass the baton or pass the buck over to our esteemed colleague, Kishara, who understands the issue of the social media, professionalism and ethics in social media 20 times better than any other member of the OCBA, or I'll say any attorney who's been practicing as long as I have does. The idea here, and this is really the basis of professionalism in general. The goal of professionalism, just like ethics, which is a subset of professionalism, is to maintain the integrity in the practice of law. And this is something that's really, it's an issue in every aspect of the practice of law. The integrity in the practice of law is vital to preserve the public confidence, the level of public trust and confidence in what we did, essentially the third branch of government, and the independence of the judicial system, of the judiciary and the judicial system. Again, the third branch of our government, either at the federal or the state level. And the professionalism is something that it's sometimes difficult to understand when you're in law school. It's difficult often for a lot of attorneys to understand when they're practicing, and it's something that we learn about every day as attorneys. I've been practicing 24 years, and I'm still learning about professionalism. But it's probably the most important thing Certainly one of the most important things you can learn as an attorney when you're practicing law. Again, the ethics are more of a subset of professionalism. The area, and again, professionalism and ethics to a certain extent are often difficult to define and comprehend. I mean, it's not clear, it's not black and white. It's like, it's like any area, any substantive area in the practice of law. I mean, it's kind of a field of gray. But this particular area, professionalism in social media, happens to be one of the more elusive areas in ethics, and it's probably one of the areas, it's where issues are arising more, every day. These are newer issues. These are issues that, attorneys in my generation aren't as knowledgeable. But they're certainly an emerging area and an emerging topic, in professionalism. And we're very fortunate to have a member of the Florida Bar who deals with these issues every day. So I'm going to hand it over to our, resident expert.
Thank you. And Eric, I know you were introducing yourself. I think you definitely will have some valuable insight, I guess, with regard to policies that are in place, like in a big firm or medium-sized firm atmosphere, with regard to social media, because that's something I haven't worked in that setting, so I don't know what policies are in place in firms and that sort of thing. So I'm actually interested to kind of hear your thoughts on that, or how your firm handles those things as well. So I think the students will benefit from hearing that as well. So just to kind of get started, it's weird for me to sit down. Sorry if I stand. I just feel like you guys over here can't see me sitting down, so I don't want to sound like I'm talking from the box. But please feel free to jump in at any time on anything that I say. I'm just going to talk freely. You guys, if you have questions or anything, please go ahead and let me know. Social media is one of these things that our use of it is growing all the time. There's different avenues that are, presenting themselves for us to be able to access on a daily basis. And so whenever I give any sort of lecture or have a talk or conversation about social media, I always like to survey the room and find out exactly what you guys are using, and just kind of tell you a little bit about it in context of what the ABA is seeing, because the ABA does their survey every year where they monitor our social media usage. So just by show of hands, we'll go down through some of the more popular sites to see who's using what. How many of you have a Facebook page? Raise your hand. Okay, that's almost everybody. Yeah, you guys. Okay. Okay.
Period.
Look at you trying to be technical. Okay. Do you have a personal one or just for your firm?
I have a personal one.
Okay,
Yeah.
so not one for your firm. Okay, gotcha. How many people have a Twitter account? Raise your hand. Twitter is like really falling off. A lot of the lectures I've given, like the number of hands have decreased over the years. I guess people are not really feeling Twitter like they used to, because there was a period of time where Twitter was really rivaling Facebook. Everybody was on both simultaneously.
What is Twitter?
That's where you have like I'm like, hold on, I'm about to explain this. What about Instagram? Who has an Instagram page? Okay. Instagram. Okay. Are you being serious this time?
I've heard that. I just don't know what it is.
Instagram's more for pictures.
Folks, I'm 52. I'm the age of 50.
I'll be honest, my Instagram page is literally so that I can follow celebrities. I like to see what LeBron James and Steph Curry are posting on Instagram. I'll be quite honest with you. My page, I really have like 3 pictures on my page. I just like to see their stuff.
What they're posting about each other?
Yeah.
Or just...
What they're saying in general. I like to kind of see. I'm a sports fan, so most of the people that I follow are athletes. I'll be honest with you. So that's just kind of my Instagram. What about Snapchat? Any Snapchat people? Okay. What else is there? LinkedIn. How many people have a LinkedIn page? LinkedIn.
What about like having people use it?
How many people update it regularly? No, just joking. If you have one, that's sufficient. And lastly, bloggers. Do we have any bloggers in the house? Bloggers. Okay. I always have 1 or 2. That's the one thing I'll say. I haven't had a room yet where I didn't have at least 1 or 2 bloggers. So thank you for saving me back there, because I don't know what I'm going to do if I get one where I don't have a blogger. So essentially, based on just your hand raises, that's pretty consistent with what the ABA survey has come out and said. Unique to you guys, or a little separate because you're still in law school, you're not attorneys yet, I will give you the numbers, at least as far as law firms, because John did ask that qualifying question, am I talking about personal usage for Facebook or law firms? The ABA survey said of the attorneys that they surveyed, 57% of them said that their firms maintained a Facebook presence, so their firm had a page. But literally, I think it was around 80-some% that they had personal Facebook pages. So that's right on line with this room. I mean, we were over 90% in this room. I think there were only about 2 or 3 people that said they didn't have Facebook pages. The other thing that I think is neat that the ABA survey researches is that they do surveys for people who are, I guess, potential clients, people that are looking to hire lawyers and those sort of things. And one of the things that they found is that a number, I think it was like 90% of the people that they surveyed said they look at lawyers' LinkedIn pages before they hire them. And so almost everybody in this room said they maintained a LinkedIn page, which is good. And you know, when you guys go out into the practice world, keep that in mind. Granted, this might change in a few years when some of you get out, but know that clients are looking at those pages. And they said they're doing it because they want to see where the lawyer went to school. They want to see what clubs they were involved in when they were in school. They want to see what charities they are involved with, because you know you normally like those sort of things on LinkedIn. So it's important to them to kind of get past that stale bio that we see on the firm website, and they feel like LinkedIn is, I guess, a better snapshot into the lawyer as a person. So a lot of them are looking at attorneys' LinkedIn pages. And what we found whenever I do this lecture or I talk to people about social media, almost everybody has a LinkedIn page. I got my page a couple years ago, only, I'll be honest, through peer pressure. I didn't have one. And one of my cousins was like, how do you not have a LinkedIn page? Every professional has a LinkedIn page. And I said, really? And he said, yeah, so I created it. But to the young lady in the back that said how many of them update it regularly, I don't update it regularly or anything like that, but I do have the page just because, like I said, peer pressure. So in any event, tying it all together, with the Florida Bar, what we do, we look into allegations of attorney misconduct. And one of the areas that was novice and was new for us was social media, was Facebook, because it hadn't been around. And so when we started seeing cases that involved lawyers utilizing their social media pages to violate the rules, it was definitely a new deal for the bar, and the bar had to figure out how we were going to adapt and move forward and change with the times. And so the first case that we saw that had anything to do with social media was back in 2008. It was a blogging case out of South Florida, and the attorney, Mr. Conway was his name. In this particular case, what Mr. Conway did, down in South Florida, there was some blog that talked about all the happenings and the goings-on at the courthouse. And apparently lawyers would comment on this blog, like everybody, you could write comments and you could make posts. And it was kind of, you know, the As the World Turns of the Fort Lauderdale courthouse, essentially. And so Mr. Conway was upset with the policy that one of the judges had implemented in the courtroom. He said it was some new, it was a 1 week to prepare policy, and he posted this blog about it, and he listed the judge's name and the title of the blog. He said it was Judge so-and-so's new illegal 1 week to prepare policy. And in the blog, he proceeded to call the judge an evil, unfair witch. He said that she was seemingly mentally ill, that she was clearly unfit for her position, and that she didn't understand the rules of ethics. And in the beginning of the blog, he called her an evil, unfair witch. And then he put EUW in parentheses so that you would know throughout the rest of the blog when he put EUW, he was referring to her as an evil, unfair witch. So he was very deliberate in the comments that he made. And so essentially what happened, someone saw the blog post and they reported it to the Florida Bar, and the bar opened a file and they investigated the issue, because essentially we have a bar rule, 4-8.4D, talks about the fact that you can't disparage people when you're dealing in your court cases. It talks about lawyers, it talks about jurors, litigants, everybody. We have another rule 4-8.2, which talks about how you can't make comments with reckless disregard about judges. And so a file was opened on Mr. Conway, and Mr. Conway ultimately received a public discipline. And I can give you guys the site before we leave if anybody wants to look him up, or I can give you his name if you go on the Florida Bar's website where you search that page that says lawyer discipline history or find a lawyer. If you put it up, there's a tab that says 10-year discipline history, and it'll say yes or no. And if an attorney has a discipline history, it'll say yes. You can click on that yes, and all the documents from their bar case are available for you to review. They're public, and they remain on our website for 10 years, but they're public forever. So anybody can contact the bar to get those documents later on. But yeah, I'll give you the name so you guys can check it out and see all the information about Mr. Conway's case. What's unique about his case? I'm sorry, you asked.
So what did Conway just describe in the blog? How burdensome or unfair the practice was? Or,
that's different.
Yeah.
He got in trouble because of the name calling.
Right.
That was the issue. Yep. And what I was going to say, what's interesting about him is that the judge he complained about subsequently faced JQC issues because other people did it the right way. They complained to the JQC instead of going on a blog and calling her names. So there's a way to handle these sort of issues. And had Mr. Conway have gone about it the way some of his colleagues did, then he would have the public discipline that we see and that we use in our lectures to this day.
What does JQC stand for?
Oh, sorry, the Judicial Qualifications Commission. And so they are the agency that investigates judicial misconduct. The Florida Bar, we regulate lawyers. And the JQC regulates the judges. And the Board of Bar Examiners deals with you guys. And so I always like to give that distinction as well, because at the bar, we won't have jurisdiction over you until you become an actual attorney. So while you're in law school, it's the the Board of Bar Examiners that deals with you all. They're the ones that do your bar application and all that fun stuff. And so essentially, I think the important thing to think about with social media is that there's no reasonable expectation of privacy with your page. And what we've seen with some of the cases that we've had at the bar is that lawyers will say things like, well, I only meant for my friends to see it. I put it on my Facebook page, but it was only meant for my friends. I didn't mean for the judge to see what I said about them. I didn't mean for opposing counsel to see what I said, because opposing counsel and I are not friends. And what the court has held is that there's no reasonable expectation of privacy. Once you get it out there into the world, you can't then say, I didn't mean for anybody else to see it. Go ahead.
So, Sheriff, if I change my privacy settings and only allow my friends, and that's about it, to access my page, can the Florida Bar require me to provide them access? Or do you all have any tools to get around the privacy settings?
You want me to give you our secrets? No, I'm just I'm teasing you. Essentially, I'll tell you how it normally happens. One of those friends, as you said, you only want your friends to see it. They screenshot it and they send it to us. One of those friends gets offended and sends it to us. I've had cases that have literally come to me because somebody saw something on a person's Facebook page and they screenshotted it with their phone, printed it out, and sent it into the bar, emailed it, mailed it, or whatever. And so saying, well, I only want my friends to see it, those are the people that are normally telling. And I always like to say, someone, somewhere, somehow will see it and they will report it to us. And so
would that be analogous to somebody in a bar making a very negative, derogatory comment, disparaging comment regarding a judge and somebody overhearing it?
It's different.
Okay.
Because people have difficult days in court, and a colleague might come to you and say, Judge so-and-so was really mean to me, he was nasty to me today, that sort of thing. That's different because it's a one-on-one conversation.
Right.
What the court's position and what the bar's position is, when you put it out into social media, that's not a private conversation anymore. It is something that you have now opened to the masses.
Right.
And so that's the difference. Because you guys will see in the practice, you're going to have frustrating days. You are going to get annoyed, and you might want to vent. You should always remember to be professional and not, be derogatory when you're talking about judges or opposing counsel and that sort of thing. But we do understand that there's bad days. You guys might have some rough days here in law school. but it's when you shout that from the rooftops, and essentially making a Facebook post or a Twitter post is shouting it from the rooftops. That's when it becomes a problem. I think I saw a hand here first, then I'll come to you, sir. Yes.
You know, I guess there's that fine line. I understand, obviously, there's issues about making disparaging comments from judges. The guy was an idiot. But can you give us some examples? Because there's obviously that balance between First Amendment and, you know, what are some of the examples? Like you said, someone screenshot it and sent it to you. Can you give us some of the examples that people have posted on Facebook that they shouldn't have, that they've gotten in trouble for?
Yeah, I can do that. And just to touch on the First Amendment thing, because you guys, you're still law students, so you haven't learned this yet. The Supreme Court has long held, and I mean long held, we're talking going back to the 50s and 60s. Once you take that oath of attorney, you give up some of your First Amendment rights. You do not have the same First Amendment rights as your non-lawyer friends. So the things that they get to say, you do not. And that's essentially part of the process of becoming an attorney. The Supreme Court has held the practice of law is a privilege. It is not a right. It is a privilege to be a lawyer. It is a privilege to be a member of the bar. So when you take that oath, you give up some of your rights. Essentially, that's what you do. And so to give you an example, of a couple cases. I talked about the first blog case that we had. I'll tell you now about the first Facebook page that we had, actually. Let me find it. Give me 1 second. This was a gentleman who was an assistant state attorney down in South Florida. And I promise you I'm not picking on South Florida. Every time I start talking about these cases, you'll see a lot of them are from South Florida. I'm born and raised in Miami. I love South Florida, so I always have to give that disclaimer. I'm not picking on South Florida. But just to let you know, yeah, so
I'm born and raised in Miami too.
Yeah.
I'll be the first person to pick on South.
I always say that because literally one time I did a lecture and we talked about some of these cases, and somebody came up to me afterwards and he said, man, you were really picking on South Florida lawyers. All your cases were from South Florida. I said, I promise you, I'm not. I'm from Miami. I wouldn't do that. It just so happens the ones that we use to lecture, those are the ones that are from down there. So in this particular case, I'm sorry that I'm struggling to find it because I want to read to you some of the comments that he made. If not, I'll have to go off my memory, and that can be a tricky thing. Give me a second. I'll be here. In this particular case, this came in 2010, and he was an assistant state attorney down in South Florida, and it was I think it was a murder trial, and while the jury was deliberating, he decided to get on his Facebook page and compose a poem to the tune of Gilligan's Island. And in this poem, you've heard this one before, I think I heard you guys, yeah, he decided to call the defendant a gangbanger. He called the opposing counsel a weasel face. He said that the judge was confused, that the members of the jury were confused. He said there was no integrity in the hearing, no ethics were involved. Those were the things that he said. What happened in his case, he was the first Facebook case that we had. He received what's known as a diversion in bar cases, which is similar to a diversion in a criminal case. If you have an issue that we believe violates the rules, but it's not the worst thing in the world, you can get a diversion. And it means you go to a class, you take a course all day that talks to you about different areas. We offer a number of different classes for different situations. He had been practicing less than 3 years at the time that this happened. So when he posted the poem on Facebook, somebody saw it, they sent it to the bar. He also made the cover of the newspaper. If you Google Gilligan's Island poem, you will be able to read everything that he said. If somebody has their smartphone out right now, you can Google it. It will pop up. He made the cover of the newspaper, and essentially he got in trouble with his job. He wasn't fired, but he did get in trouble, and he had the bar complaint. And what happens with the diversion, the committee decided, since he was so young, he'd been out less than 3 years, they did not want him to have a permanent discipline or a public discipline like I just talked to you guys about, where you could search him on the bar's website. So they gave him the diversion. He also had to write letters of apology to the judge, to the defendant, and to the opposing counsel. And he had to take the diversion class and pay. for that class, and the cost of the class, I think, is like $750. And I know you guys aren't out in the practice world yet, but let me tell you, as a former public defenders and state attorneys do not make a lot of money at all. So to have to cut a $750 check, that is a huge deal for somebody who works in that form of government service. So the committee really took those things into consideration when they gave him that sanction. But even though his case isn't a public discipline, because it made the newspaper, people are still talking about it now. Like I said, if you Google it, it's still out there. I've been using him to lecture with since 2010, so he's living on in my lectures because, seriously, because of the nature of the case. I see a hand in the back. Yeah.
What was his time frame to take care of that diversion and write those letters before it went away?
Sure. Normally, when you get a diversion, they ask you to have it completed within 6 months. So you get a 6-month window to pay the cost, to sign up to take the class, and you can get an extension if the class isn't coming anywhere near you, because we normally teach the classes as bar counsel. I teach the ethics school class, which is what he was sent to, in Orlando, and I only teach it once a year. So if when the discipline came out, or the diversion came out, if let's say the South Florida class had already passed, he could ask for an extension to take it the next time it came around so that he didn't have to travel. But what they would make him do is pay the cost, though. He would have to pay that. But then to write the letters, those would have needed to be completed within the 6-month time frame. And he did that. And so another example of a case that I had where we received a screenshot was a lawyer that had a motion to recuse against a judge. It was granted. And she posted on Facebook in celebration of that fact and said, "I never have to appear in front of that crazy woman again." And she listed the judge's name. She said the judge's name and said, "I never have to appear in front of that crazy woman again." And so somebody saw it, one of her friends, like I told you, screenshotted it and literally sent it into the office. And they were really old school about it because it wasn't emailed, it was mailed with no return address or anything. That was mailed to the office. And yeah, and it came on, I got it. It was assigned to me, and so we had to open a file. And she was really distraught about that people had seen it and that they found out about it. She's like, "It was just from my friends, and my friends know what I'd gone through with that judge." Well, obviously one of your friends didn't like the fact that you said it, because they had to have been the people that sent it to us, or they showed it to somebody else who screenshotted it and sent it in to us. You had another question?
I know, it's not like I'm trying to find ways to post things on
I mean,
Facebook.
no, it's fine.
But what if, for example, in that case, what if that woman did not put that judge's name?
Well, that's a little, I think with that instance, because we wouldn't know specifically who she's talking about, if she just said, "I don't have to appear in front of this crazy judge anymore."
Yeah.
Now, could there be speculation as to who she was talking about? Sure. Would it have been as bad? I don't think so. And I see where you're going with it. And somebody probably wouldn't have sent it to us.
Yeah.
But what I'm thinking happened is one of the lawyers, one of her colleagues, probably has a good relationship with that judge, saw her post, and did and maybe told the judge. And maybe the judge was the one that sent it. I don't know. Like I told you, it came, no return address. It was mailed to her.
I will say this, as a general rule, don't ever say anything negative about a judge to anyone.
Yeah. That's
Other
the
than
general
you
rule.
respectfully disagree with the judge's decision,
Yeah.
which you can say.
Yeah. Because-
And there's a lot of different ways to say that.
say that.
And if you're an appellate lawyer, you'll be saying it on appeal. In fact, I think some of the appellate lawyers I know, the best appellate lawyers, who are constantly, representing, appellants, in their, consistently representing appellants in their appeals, are some of the most respected lawyers in Orlando, simply because they are very respectful in how they describe the judge's opinions, the judge's rationale, and reasoning, and holding, and everything else. So yeah, I mean that's just a good thing to follow.
Yeah. And just to follow up on what John said, it wouldn't be as bad in the sense of you probably wouldn't get a diversion or anything like that, but I can tell you somebody's going to file a bar complaint against you. I always tell people, like the little boy on The Sixth Sense sees dead people, I see bar complaints. You write on your Facebook page, the judge is crazy, even if you don't say their name, somebody's going to send that to the bar, and a bar complaint will be opened against you. And you don't want to have to see a letter from the bar come in the mail or an email now because we're paperless. We send emails now. You don't want to see an email pop up from us telling you that a file has been opened. And that's definitely one of the ways it will happen. Yes?
So is every complaint turned into an open file? Even if it's like dismissed, is it always turned into an open file?
If somebody sends something to the bar in writing, into our Tallahassee office, that's how most of the complaints are generated. They contact our ACAP office, that's Attorney Consumer Assistance Program. If they send something in writing, then yes, a file is open. Now, open does not mean that it's public. All of our bar investigations are confidential. They become public at a certain period of time, and I'll just go over quickly what those times are. If the file is closed, if we don't find probable cause, or if they issue a letter of advice where they're saying, we don't believe you violated any rules, but your conduct kind of towed that line a little bit, once it's closed, that becomes public. But it's public in the sense of somebody would have to call the office and say, John, I'm just using you as an example, you don't have any open files. But they would have to call and say, do you have any files or any public information on anything pertaining to John Benford? And even though that file was closed, we would have to produce all the public documents in that file. Now, that only happens for a year after it's closed. So on November 1st, 2015, that file only stays open until November 1st, 2016. So literally, today, November 2nd, that file is purged from our system. It's destroyed. So if somebody called today and said, do you have a file on John Benford, one that we closed on November 1st, 2015, we would say no, because it literally, they get destroyed at midnight or whatever. Our system eats them or does whatever it does. No, seriously, and I checked it one time because I'm that person that likes to know this stuff, so I literally checked it and they were gone. And I was like, oh, that's pretty cool. That it really does do that. So they disappear. So it's public in that sense. If probable cause is found, if the grievance committee investigates and they believe that you have violated the rules, once they find probable cause, the file is then given back to the bar council and we have to draft a formal complaint to file with the Supreme Court of Florida. But that probable cause finding is public. So if somebody calls and says, do you have anything on John Benford, and the committee just found probable cause? Yes, we do. And you can inform them of what the rules are that the committee found probable cause on. You give them the explanation that those charges haven't been proven yet, we haven't filed a complaint, this is simply that the committee has found probable cause. But yes, it is public at that point. But everything we do is confidential. It's very, very secretive because we do that to protect the lawyers. You don't want a bunch of people to know you have bar complaints. I mean, some of the best lawyers that I know have had files come in my office, and those files have been closed quickly. That doesn't mean that they didn't have to go through the process of responding and doing those sort of things, but we don't want anybody to be judged just because you have an open file in the bar's office. So that's why we make sure that we keep those things secret. And we do a really good job of it. I always joke and say I work for a super secret spy agency because they make sure that everything, I mean, we've got all sorts of protections and things up, and we can't access things in certain places. Like, they're very, very strict about what we can do to make sure that we are protecting the attorneys who we're investigating.
My previous question that I wanted to ask earlier was about our freedom of speech. At what point do we regain that after we stop being an attorney? Like, when we retire, do we then have the right to speak freely and not held on to the same? Is that like a lifelong permanent thing?
Own you forever? No, I honestly don't know when you get them back. I mean,
because I don't know if I want to be an attorney forever. There's like
Yeah.
lots of other areas of like business and real estate and development that I really want to focus on. And I don't want, if I'm critical of specific state legislation, I don't want my speech to be restricted. You see what that's
Yeah.
kind of the basis for that question.
I don't know when you get the rights back. I've never had anybody ask that question. What I can tell you is there is an opinion that came out.
Would it be as long as you're a member of the Florida Bar?
Yeah.
That's what I would think. I would think as long as you have an active license,
Standing, yeah.
you would be considered. Here we go. Oh wait, wrong page. As long as you have an active license, they would consider you somebody whose speech is restricted.
And
So
other states have similar standards?
they do.
Okay.
I will tell you this, we're one of the more strict states. A lot of states try to model their bar procedures and practices behind us, simply because I think we're one of the largest states with regard to attorneys. We have like 103,000 lawyers in the state right now, so we have a more sophisticated system. Not the most sophisticated, but we have one of the more sophisticated systems. And we do tend to be a little more strict, which is also why we don't play well with the other states, and we don't have reciprocity and all that other stuff, like we don't play nice.
Yeah, it's an interesting question, though. I mean, you watch the news. I mean, everything from, CNN to Fox to MSNBC, whatever.
Analysts.
Right. You have former attorneys, or at least people who did practice law at one point. I don't know if they're still members of bars, but they're making all kinds of
Also their opinion.
all kinds of things that may not be the most right, flattering about various people, including judges.
Yeah, that's true.
So.
Just really quick, I want to go to those cases that I told you about, just so you can get an idea of how long the court has been saying these sort of things. In State v. Fishkin, and it's a 1958 opinion, the court held that the practice of law is a privilege which places special burdens upon those choosing to pursue this honorable profession. Law, being a jealous mistress, makes extraordinary demands upon members of the bar. And then in 1973, in the Florida Bar versus Bennett, the court said, an attorney is an attorney is an attorney, much as the military officer remains an officer and a gentleman at all times. So we're talking a long ways back that they've said,
Wow, that's sexist.
Jealous mistress, yeah. And here I am using them as examples, but I do that because I want people to see how far back they've gone to say, we don't have the same rights that everybody else has. But I've never had anybody ask me that question before, so I'm actually going to go back to the office and pose that to my boss.
And then the next part of my question is, are we allowed to be critical of stuff that that our state government is doing as attorneys? I mean, specifically, I'm very critical of amendment that just came out on this ballot, Amendment 1.
Solar amendment.
Is it?
Yeah.
But just the way it's worded and the amount of money that was put into it and the amount of legal professionals that were used to craft it, I don't think it's putting people on a fair understanding for the average human being. Because the way it sounds like it'll be great, and solar power will be everybody, and your solar bills will go down, and we'll protect you, and we'll give you this right to put solar panels on your house that you already have. And just a lot of the wording of it offends me, and the basic idea offends me, and it really looks like it's predatory of senior citizens specifically. So they're going to look at it and sign yes all day and not really understand what they're. So if you're critical of something like that, I mean, is that something the bar can look into, or are we allowed to be critical of something like that?
Are you critical without being disparaging?
Yeah, not attacking any individual specifically.
I would encourage you to read Rule 4-8.4.
Okay.
D. That's the rule that comes into play in a lot of these cases. And that rule talks about how you can't disparage. And it gives you a whole list of ways. It talks about on the basis of race, religion, sex, national origin, ethnicity. It lists them out. And so if you feel compelled to be critical, read that rule and make sure you're not running afoul of it. Also read the oath of admission to the Florida Bar, because back in 2011, the court changed the oath. We had a different oath that all of us took when we were sworn in than what the oath says now. And in 2011,
I took this one.
oh, you took the new one? Oh, really? I didn't realize that. Okay. Yeah, 22. Okay, sorry. I'm the old dog. I took the old oath. Essentially, in 2011, and I see hands in the back, I'll get to you guys, but this is important for you guys to know. In 2011, the court on their own amended the oath. And that's important and it's unique because typically the court doesn't amend anything without them, they impanel a group of lawyers to do research and to write briefs and things to ask them to make amendments to the rules and that sort of thing. September 2011, we were all sitting around in our offices, and anytime the court issues anything, any sort of opinion that's bar related, we're notified of it immediately. And so we were around in our office and this opinion came out with them telling us they were changing the oath. And they wrote this full opinion because they were tired, they said, of what they were perceiving as a lack of professionalism in the practice of law. And so they added that paragraph that said, to opposing parties, I pledge fairness and integrity in all written and oral communications. And that didn't used to be in the oath. It wasn't in the oath that I took. And so on their own, they issued an opinion, and I encourage you guys to read it. If you haven't already, you might have read it in your professional responsibility class. but they talk about their reasons for changing the oath. And that's important because that was them putting us on notice that they're very, very serious about what they consider to be professionalism issues. So disparaging people on social media, that's a professionalism issue, and they want to make sure that they're doing their best to regulate it. And so that's why we're seeing the complaints and we're seeing the anonymous screenshots coming in the mail and that sort of thing. So I just wanted to point that out.
I was just going to say, it's a very good question, whether or not you can make disparaging remarks or what types of remarks you can make regarding members of the Florida legislature or U.S. Congress or people.
Well, I wasn't attacking a person specifically. I was
right, but
attacking
well, that's a very important distinction. Is are you attacking a person or are you attacking an idea, a legislative process, or proposed legislation or legislation that was actually passed? But with the bar, with the bar, and that may actually constitute a violation.
Yeah.
But what the Florida bar and what the rules of ethics and professionalism try to focus on primarily is how you interact with other lawyers and judges, other members of the bar,
and parties to
yes,
the litigation as well.
Parties to the litigation process, the actual parties, as well as witnesses, people that are participating in judicial proceedings as either witnesses or parties, attorneys or judges. Yeah. So, I don't know.
So I work in some law firms, and I'm sorry, but this would be relevant to, and I can't see your last name, Eric, but I would like to get your feedback about the Facebook policies and blogs as it relates to law firms, because the ones that I worked in, they didn't have any established rules or procedures. There were some iffy lines that I came across myself, so I would just like to hear your comments about that.
We have a firm Facebook page that's not really active. We have a firm LinkedIn page. We have a marketing group that we meet with regularly that we basically, it's all, and this goes for a lot of law, it seems, you spend all this time learning the technicals, and a couple of years ago I looked at different policies that were in writing. There was one law firm in Chicago had a really detailed policy. When it came down to it, it was common sense. A lot of these general policies that were not directing comments to people individually. We don't use, another important distinction is we don't use our social media for the purpose of obtaining clients specifically, so it's not directed towards clients. We're careful to avoid anything that has the appearance of being advertising, because the bar is strict on advertising. Our primarily LinkedIn we use to communicate with other professionals that we deal with, who we engage with. And so everything that gets posted on all the attorneys' pages, we monitor that, and it closely tracks what's on the bio pages. So you're not going to find a lot of different information or a lot more personal information, maybe add a little bit of personal biographic information for the attorneys, but it's not going to be substantially different than what's on the firm page. Any postings get reviewed thoroughly before they go on. So we typically will meet and on Thursday afternoons and review anything that any attorney is going to post that might go out specifically to LinkedIn. We'll find that that's a primary means of communication. And in fact, now with what we're really worried about is spam, because you get these lists of people, and people have their different contact lists, and if you send something out, you run the risk of being put on the naughty list for spam. We want to avoid that. LinkedIn allows you to create groups, and now you have essentially what's a closed communication system that everybody has opted into. And there's a degree of integrity because it's been around for a while. People know what it is, and professionals can opt into these groups, and that's for use for communication. But written policies, we've tried to. We started out. We do have a policy manual, and basically it just says that the social media pages are subject to review at the firm's discretion.
There's the Florida bar has, like Eric, I'm in a firm with 800 lawyers, and there's a whole department. You can't put anything on the firm web page or your sub page or whatever without going through the department first. But for a long time, I had my own firm, and I never advertised via social media. I have the very basics on, I was one of the last people to get a LinkedIn page, and I have just, essentially the most basic resume on there. But the Florida Bar is a great resource. I mean, they have, a whole team of ethics lawyers, really that can address any kind of ethical question or issue. And of course, this overlaps with professionalism. But advertising is a big area, and it's a big area in a lot of practices, in particular plaintiff's personal injury. It's very important to advertise. And a lot of attorneys depend on it. And it's not just plaintiff's personal injury, it's a lot of different practices, and attorneys are really dependent on advertising. But they have a whole team, making sure you interject any time I'm misspeaking, but they have a whole team of lawyers up in Tallahassee that do nothing but review attorney advertisements. So if you send the advertisement, not only do they have a lot of rules and standards and examples of what you can do and what you can't do, but if you send the advertisement to the Florida Bar and say, can I do this? Or do you see any problems? They will respond, quickly, from what I understand. I've never said anything, on advertising, but I certainly contact the Florida Bar probably once a month just to get an opinion on an ethics issue. And I don't think I've ever waited more than 30 seconds on the line for an attorney who's always given me just a very thorough analysis of the issue. But yeah, go ahead. Yeah.
Oh, but I was going to ask because, well, all three of you, no offense to you,
No.
but they're in law firms. So when you guys are looking at, to hire or to suggest, I guess I can say, other attorneys, how active, I understand the LinkedIn page is definitely something that's going to be used, but how active are you guys maybe looking into Twitter, Facebook, like Instagram, like how far maybe back are they going as far as like pictures go? Because like, for example, when we first got to Barry, they were like, listen, a lot of pictures, y'all just need to take them off. They're like, if you have a cup in your hand, state juice or something, but a cup, a bottle, no pictures kind of out there. So I just want to know how far back are you guys really, checking? Is there an extensive check of that?
I can tell you, if we're going to hire somebody, I have somebody in my office who goes back and does a general search. You go to Google now, you search Google. Just because something's deleted, it doesn't mean that it's gone.
What is it called? Time machine, right? Or it's something where it literally...
You can find Google Archives.
Yeah, Google Archives.
And mostly it's to substantiate the resumes that we receive. And we've hired two attorneys in the past year and a half or so, close staff-wise. Another issue that's becoming prevalent, that's related, is how you use social media to investigate other people. And this is kind of becoming an area, another subset in areas of evidence, and it has an interplay with ethics. Is it okay if you're trying to find out about an opposing party or about a witness to look at their social media? If it's public, it's public. Is it okay to friend that person if you're in the middle of a lawsuit? Is it okay to friend somebody in order to get information? And these are issues that are, I don't know if anybody really has the answers, and much like John, when these crazy questions come up, I'm quick to call the bar as well, to the hotline.
So back to kind of his question, you guys have a way over that private, friends only kind of Facebook.
Yeah, the way the courts look at it, there's a case on the evidentiary side that involved Target Corporation. It's pretty recent, maybe within the last 2 years. And an issue that came up was this Facebook, well, I only let my friends see it. Friends can share. And so somebody takes your information and shares it with somebody else. Once you put it out there and you let somebody else look at it, and that's from an evidentiary side, they've looked at it and said that's public, which is consistent with the bars.
Yeah, I've used it before. My paralegals have used it before as far as discovery, trying to obtain information about a witness on the deposed or something. I don't think I've ever used it as evidence in a trial, but...
And I think it was for a while that PI lawyers would tell their clients, like, get rid of all this stuff, take it all down, and now you've got a preservation issue. You can't destroy this stuff. You can certainly remove it from the public view, but you can't destroy it, and now you have spoliation of evidence. So, and you had said something there.
Yeah, mean, if they accept your friend request, that's on them.
You have a higher responsibility as an attorney. And so it goes back to what Kishara said. Once you take that oath, you have a higher responsibility. So just because a potential, the same as in dealing with third parties, and there's rules on fairness in dealing with third parties and dealing with unrepresented parties, that you have to be conscious for their rights. So if I have a conversation with somebody, I do business litigation. I'm mostly dealing with business owners and in that realm. But if I have a conversation with somebody who's unrepresented, I need to make it very clear from the beginning. I don't represent you. I represent somebody else's interests. If you have an attorney and you want to get your attorney involved, I encourage you to do that and let them know that from the beginning.
And I know that the Board of Bar Examiners looks at the social media pages. I'm not quite sure how they access you all's pages, but I do know that they look at Facebook and those sort of things when they're doing that background check. I know that they look into that stuff. I don't know how they do it. I'm not privy to that. But that's also something to be mindful of. That's probably why Mary told you when you first got here to clean your pages up, because they know that the Board of Bar Examiners is looking into Facebook and Twitter and those sort of things. So that's just kind of, I mean, it's one of those things. I always like to leave people, and I know our time is kind of winding down, but what I always say, if you take nothing else away from what we've said today, the best rule of thumb is the Exhibit A test. Don't post it if you would not want it attached as Exhibit A to a pleading before the judge. I didn't even get into a lot of the other cases that I have on social media issues. In a lot of those cases, the attorneys ended up in the newspaper. I told you about one case where it ended up in the newspaper. We have others. Or motions were filed with the judge and what they posted was attached. So that's, I think, the best rule of thumb to have. If you don't want the judge to see it, or if you don't want it to end up in the newspaper, if you would be embarrassed if it ended up in the newspaper, you need to be mindful of that. We are all young folks. Social media, sometimes it's so immediate and it's so quick, and I always tell people our thumbs move very, very fast, because I know my thumbs move fast with the best of them. And don't let a couple minutes, ruin your career, or, put your career on a different track because you were frustrated leaving court one day, or the opposing counsel was very difficult to work with today, and you decided to go on Facebook and post a rant about how difficult he is to work with. Make sure you're keeping those sort of things in mind. So remember that Exhibit A test when you're making those posts on Facebook. My general rule, I don't talk about work on my Facebook page at all. I just don't do it. I mean, honestly, I really, really don't. If I'm posting on Facebook, a lot of times it's about sports, because like I told you guys, I like sports, so I'm talking about my teams, if they're doing well or not so well sometimes. I talk about those sort of things, but I don't talk about work. People don't know when I go to trial. I don't post that on Facebook. I have friends who are lawyers that know what I do, and they still post stuff about what's going on at their depot and what's going on in court. And I try to scroll past real fast and not read what it says, because I just don't want to see it. And so literally when I see that headline, in my depot today, scrolling past, I don't want to read any further.
Yeah, that's an excellent rule. I mean, keep the personal, keep all your personal stuff. If you're going to have a Facebook page, on your firm, on your business, keep that separate from your personal Facebook page, or put all your firm business, run all that through LinkedIn, and then have your Facebook as your personal. And don't mix the two. Don't have clients on your, as friends on your Facebook page. Don't have, unless they're good friends, I wouldn't have another lawyer on my personal Facebook. Don't discuss business on your personal, you want to discuss sports. I discuss sports all the time, and a lot of rants, and a lot of things I say about teams and coaches. I'm not sure I want a judge to say. I'm sorry, go ahead.
You said that you scroll past. So as a board member, do you initiate complaints on your own, or only when people send it to you?
When people send things to us, I personally have never opened a complaint against anybody. I haven't had to. When I see things on Facebook, as soon as I see somebody talking about a case, I just go past it so I don't have to read it, because I don't want to be put in a position where I have to say something about it. So I just try not to see it. But I've never been in a position where I've had to personally open a complaint. I've been investigating complaints and realized that there was another lawyer involved in the situation and a file needed to be opened up against them, and I've done that. But not based on anything that I've personally seen have I opened up a file. Is somebody, do you have a question?
Just real quick, this summer I was at the state attorney's office and there was an issue. And so that was in public and news. Was that something that you had to deal with too, or is that just something that was internal? Yes.
You guys read about it in the news. It was in the news. You know, we can't really comment too much on a lot of that stuff. So you were there, you saw what happened, and I know there had been an issue before, I think, with that same person. So I can't really say much about it. Yeah. Anybody else?
I think I'm going to actually ask Mr. Robert Moore, right? You said you've been practicing law not for a long time.
Not for a long time.
So can you share with us how was for you when you first started? You know, how did you deal with the whole, you know, ACTO issue?
Well, the advice that I got when I was in law school, again, you've got that don't let this be attached to an exhibit complaint, but someone told me, hey, if you're mad about something, don't sit down and blast an email to opposing counsel, which would apply to any kind of Facebook or social media. They said, look, if you want to sit down and get it out, write it out, print it, put it in your partner's desk, and then read it the next day, and you'll see how embarrassing this would have been if you would have sent it. And I've done that on multiple occasions, and you know, there's almost nothing that warrants a response so quickly that would not allow you to have a good night's sleep and think, okay, this isn't anything that I should have sent out. Gosh, I'm sure I'm glad I didn't send this. And I would say that one thing has saved me probably